So in Arizona, we have this concept of custody. I hear people come in all the time and say, "I want custody of my kids," and that's just sort of a generic term that people throw around. But really, what custody in Arizona is legal decision making and parenting time. They're two very different things. Very simply, legal decision making is who gets to make certain decisions about minor children when you're divorced. Parenting time is how much time does each parent get to spend with the children after you're divorced. When a family court judge is trying to decide what to do in terms of custody, legal decision making, and parenting time, the primary factor that they have to consider is what is in the best interest of the children. Now, to do that, Arizona has a statute that goes through about 10 or 12 factors that the court has to consider in making that determination. We attorneys call these factors that a court considers to determine the best interest factors, really imaginative. But they really go through a number of things, such as the relationship that the children have with each parent, the relationship that the children have with other important people in their lives. So that could include grandparents, cousins, aunts and uncles, significant others. The court looks at how the children have adjusted to each parent's home. For example, if they're going to school near mom's house, how have they adjusted to that? Do they have friends in the neighborhood? Are they involved in activities? One of the most important and hotly contested issues that courts have to look at in many cases, especially in really high conflict cases, is the mental and physical health of everybody involved. That includes mom, dad, and the kids. And that can be a very, very big factor in determining what's in the best interest. The courts can also consider the wishes of the children in some cases, not every case. The statute's pretty clear that the court can consider the wishes of the children based on their age and maturity. So kids don't actually get to pick where they want, but as they get older, the courts will certainly take into account their wishes. I'm sure you can imagine that one of the most difficult issues in any divorce for parties who have children is not being able to spend as much time with their kids as they used to be able to spend time with them. One of the most important things we do as divorce attorneys is create parenting plans for the parents. This can be a big fight in a lot of cases, to be honest. And I get it. I really do. Nobody wants to be away from their kids more than they have to be. I think there's a general preference in Arizona that the parents share equal parenting time. And there's a variety of different equal time parenting plans that can be put into place. But in some cases, that's not in the best interest of the children. And so we have to look at all of those best interest factors to determine what is going to be the best parenting plan for each parent. If the parties can't agree, then ultimately the judge is going to decide. And the court's going to look at 10 or 12 best interest factors and determine in this situation what's going to be best for these kids. One of the factors that a court has to consider is whether domestic violence has occurred during the marriage. And it probably goes without saying as to why this is an important factor for it to consider. If there has been domestic violence, it can absolutely impact the parenting plan for both parents. It's not a foregone conclusion that if domestic violence has occurred, that you lose custody or that you don't get to see your kids, even on an equal time, but it's certainly an important factor. Certainly, if there's been domestic violence directed toward the children themselves, that is going to very negatively impact the abusing parent's ability to have parenting time. Substance abuse is another issue that the courts will look very closely at. Remember, with courts, when it comes to children, they have to make sure those kids are safe. They have to make sure that where they are ordering them to spend their time is going to be in their best interest. If your spouse suffers from substance abuse, in a lot of cases, the court's going to order some sort of drug testing to essentially force that parent to demonstrate that they aren't going to abuse substances when the children are around. If they're not successful in being able to do that, in a lot of cases, the non-abusing parent will get most of the parenting time. If you were to ask me what I think the most complicated scenario that comes up in divorce cases involving children, it's a situation where one parent decides, I want to move to another state. And sometimes there's really good reasons for that. Maybe they're remarried and their other spouse has a job transfer. There could be any number of reasons. But that's a really, really complicated issue because Arizona has a very specific statute involving relocation of children. It's not easy to do. You have to be able to demonstrate that the relocation is in the best interest of the children, not of the parent. And of course, one of the problems with relocation is that when a parent moves away, it's going to impact the parenting time of the parent who stays in Arizona. So this is often a situation that involves, in some cases, experts getting involved. It's very evidence intensive and it's super, super complicated. One of the difficult things that changes when parties get divorced is that they don't get to spend those very fun and special days together every year like they used to with their kids, holidays. And that can be really, really emotional. Arizona does require that any parenting plan include a vacation and holiday plan. And so most often we will sit down with our clients and go through what I call a standard vacation and holiday plan. And really, it's usually the same. Each parent is going to get half the holidays every year, and then the next year they flip flop, with a couple of exceptions. Usually, mom gets Mother's Day every year, dad gets Father's Day every year. Things like birthdays and those things are generally the same. But the big ones like Christmas, Thanksgiving, etc., those are usually rotated. In really high conflict divorce cases, it is sometimes advisable to have something called a parenting coordinator. The current rules in Arizona require that the parties agree to a parenting coordinator. The process is really simple. If the parties agree to have a parenting coordinator, which is usually a very experienced family law attorney to help them resolve parenting issues, the parties simply agree to that person being appointed by the court. And typically there's an order that is submitted to the judge by the attorneys that sort of outlines the authority of the parenting coordinator. In some very complicated custody cases, it's sometimes advisable to have a custody evaluator appointed. These are cases where there's usually some really bad stuff going on. This could be severe mental health issues, maybe a substance abuse. You're looking at those best interest factors, and you're seeing a lot of really toxic and difficult situations. Courts will sometimes want to have the advice of an expert. We call them custody evaluators. Most of the time, these are psychologists, people that are very well trained in the behavioral health area. The process is really two avenues. The parties can agree to have a custody evaluator, and they simply agree and submit that to the judge, and the judge says, yes, I agree, and signs the order. Or a judge can actually say, I want a more in-depth evaluation in this case, and orders the parties to get a custody evaluation. In most cases, the judge will encourage the parties to come to an agreement on the evaluator, but sometimes it requires the parties to submit a list of names to the judge, and the judge will choose someone. In some custody cases, you can get something called a best interest attorney. This is, of course, a family law attorney that is appointed by the judge specifically to represent the children. It's not very common, but it's usually something that occurs in cases where there are some complicated issues in the case. That could be mental health issues, it could be substance abuse, it could be domestic violence. The best interest attorney would be appointed by the judge. There's usually a small fee associated with the best interest attorney that the parties split. And the best interest attorney simply advocates on behalf of the children. Long distance parenting plans can be really difficult and emotional. It is absolutely the case that when one parent moves away and a more traditional parenting plan is no longer practical, we still have to find a plan that gives the parent who moved away as much parenting time as practical. The statute does require the courts to put parenting plans in place that maximizes both parents' time with the children. In the case of a long distance parenting plan, what that almost always means is that longer school breaks like spring break and fall break are going to oftentimes be time when the long distance parent gets time, more time, although not always. Summertime is really the time where they get most of their parenting time. And so it's often the case that the Arizona parent is going to maybe get a couple weeks of parenting time during the summer, maybe 2 or 3 weeks, and the long distance parent gets most of their time during the summertime.